Greetings to all dear colleagues, publics, candidates. Today, on January the 14th, 2025, the advisory group of experts gathered in full to conduct an interview with the candidate for the position of Judge of the Constitutional Court of Ukraine, Yezhov Anatolii. In particular, all 6 AGA members are present. AGA Secretary, Madam Maureen O'Connor, AGA member Hanna Sukotska, Yaroslav Romaniuk, Vasil Shakun, Aleš Zalar, as well as the deputy members are present: Volodymyr Kuzmenko, Vitaly Makinchuk, Mark Zubik, Richard Barrett. I note that we work in a shelter, so in the event of error rate, interviews will continue without interruption. I would also like to remind you that the interview is being recorded and broadcast live on the resources of the AGE and the website of the Constitutional Court of Ukraine. I draw the attention of the members of the AGE and the candidate regarding the restriction of the use of sensitive data and information with limited access live. If it is necessary to discuss such issues, the AGE will limit the broadcast at this time. We are ready to begin, so I give the floor to the AGE Secretary, Madam Maureen O'Connor, for a brief introduction of the candidate.
Chair. Greetings, dear colleagues and everyone who is watching these proceedings. As the chair has already stated, the advisory group of experts will now conduct an interview with our candidate, Anatolii Yezhov. Let me remind you that the interview is a mandatory stage of evaluating candidates as part of assessing their compliance with the criterion of high moral qualities. The interview is offered to all candidates. Our interviewee is given approximately up to 1 hour, and there is a time limit for answering the questions, and that is 3 minutes. Traditionally, we ask all candidates to be concise, to answer clearly, unambiguously, and to the essence of the question that has been asked. At the end of the interview, the candidate can make a short final statement up to 5 minutes. I would also like to note that during the processing of materials about candidate Yezhov, the AGE sent him questions to provide written explanations, so the candidate had the opportunity to prepare and to provide answers. So now we have with us a candidate for the position of Judge of the Constitutional Court of Ukraine who has been admitted to the competitive selection simultaneously by the Committee of the Rada of Ukraine. Anatolii Yezhov has more than 38 years of professional experience in the field of law, covering work in the prosecutor's office, banking security, financial monitoring, and international cooperation. Since 2021, Anatolii has held the position of chairman of the Council of Prosecutors of Ukraine, and since 2020 has been working as a prosecutor of the Department of the Specialized Prosecutor's Office in the military and defense sphere of the Prosecutor General's Office. Previously, he held senior positions in the Prosecutor General's Office of Ukraine and the National Bank of Ukraine. In the period from 2005 to 2012, he was the representative of Ukraine in the Council of Europe Committee on the Evaluation of Anti-Money Laundering Measures. Mr. Yezhov, if you want to add something in your presentation, you can do it now and within 2 to 3 minutes. Thank you.
Thank you for the introduction. I have nothing to add, so thank you. I'm ready to answer your questions. Thank you. Madam Hanna, please, the floor is yours.
Thank you. Thank you so much. I have one question concerning real estate, the problem of real estate. On 29 November 2014, you received a gift from your mother, an apartment with a total area of 106 quadrat meter and the cost of Ukrainian hryvnia 1,222,000 in Kiev. You still live in this apartment today. Explain the circumstances of your mother's ownership. What were the sources of funds for the purchase of an apartment?
Дякую за запитання.
Thank you for your question. This apartment, I purchased this apartment on the stage when we lived together with my children in another apartment I got from the prosecution general, and my children were already grown up, and I realized that it was time for them to start their own families, and my task was not to be in their way but to actually help them to transit to the adulthood. And I decided to buy a separate apartment. At the time, as of 2004, I was divorced. At that time, my children were also, building up their own lives, and I was looking for a wife I could live with, communicate. And I made good money in the National Bank of Ukraine. I made up to 500,000 hryvnias a year or something like that. And I would save up money for the apartment. But to avoid the risk on the stage of, initiating relationship, not to have this risk in relation to apartment, when in fact the marriage relations between a man and a woman is concluded, and I decided to suggest to make the owner of this apartment, to make my mother the owner of this apartment. My mother is a very dignified and decent person, and many people know this about her. And I completely paid for this apartment. I paid the cost, and I paid for the repairs, and I personally also was working there. And this apartment was when it was on the stage of only of the foundation, and then when it has been built, I asked my mother to make me a gift with this apartment, and I have become the real owner of it. All money with which it was acquired were made in the National Bank of Ukraine. I hope I answered your question.
You answered the question, but still, I don't understand. There are some points which are difficult to be understood. So, for example, because now it is your property because you receive a gift from mother, but before you said that you didn't like to buy the apartment because of the divorce, the problem with your wife. But now, when it's your ownership, the problem still remains. Yes, I don't know. Yes, how? What is the explanation is not clear. So maybe you'd like to say that it was 10 years ago when you became an ownership of the apartment, because you received a gift in 2014. Now we are in 2025. And what has happened in between with this apartment? Who was ownership when you received the gift, when you paid the money to mother, and very, very unclear was your answer.
Дякую за
Okay, I will try to clarify. So my previous marriage was over. I mean, it was over in 2004. We remained friends with my ex-wife, but I have no relationship with my wife. And I was looking for a woman, like I communicated with different women. So I was like in active search of a woman I could stay with, to be like my next wife, so to say. But in this situation, a woman and a man who become closer, yes, but I was speaking about the mutual trust, understanding, and feelings. This stage required months or maybe even years. And during, getting to know my new woman closer in this new relationship, to the outside observer, it could have seemed that I didn't know about the ethical, moral features or traits of this potential woman. So in order to preclude the risk of this property, I asked my mother for her to become the nominal owner. It's all was bought with my money, and the money that I got from the salary, just to avoid the risk, when, well, let's say that if the woman that I was communicating with, she could tell that we had the real marital relationship, and let's share this apartment, let's divide it, because I wanted to avoid the situation before this relationship occurs. Maybe I was trying to be too preventive, I don't know, maybe I tried to take a proper care, but this was risk mitigation for me, because such practice does exist, and so I applied it in my private life. Did I manage to answer your question?
Yes, I hope I can, to some extent, I can understand that you would like to avoid the situation that your future wife would marry your apartment, not to you. So for that reason, you decided to explain clearly that it's not your apartment, yes, but it's your mother's apartment. Okay, so now I understand. Okay.
Анатолій Володимирович, давайте продовжимо.
Anatoly Volodymyrovich, let's continue the block of questions about the movable and immovable property. Mainly in 2013, you have purchased the garage, and with a total area of 17.1 square meters and a cost of 24,000 hryvnias in Kiev. At the same time, in your declaration for the period from 2019 to 2023, you note the cost of the garage on the date of the acquisition of ownership was 150,000. Could you please explain the discrepancy? In 2014, okay, as for this garage, I have purchased it in 2014 with 24,000, and the declaration for 2014 I didn't specify its cost, but in 2016 I have specified the cost of the garage for the date of gaining the ownership, 24,000, and the cost of the garage on the date of the assessment, and I got it from the head of the cooperative, and he told me that approximately this garage can cost 150,000 hryvnias in 2016. But in 2019, using that same source, the head of the cooperative, I found out that the price of this garage was 150,000 hryvnias. So this was not special evaluation, it was an empirical approximate number of the head of the cooperative who knew the prices for such property in our cooperative. And since this was the last amount that I knew, that's why I would enter it. I think they didn't tick the cluster correctly, because I have specified, I ticked the cluster of type of the value of the object on the date of acquisition of ownership, but in fact it's the cost of the object in 2019 that I learned from the head of the cooperative. So the last known price for this garage, that was the one that I have specified. So the question as for you as a lawyer, do you think it is correct to specify in the declaration the information that you got orally from the head of the garage cooperative? Well, it's just that I thought that that previous amount that was smaller, that it wasn't relevant anymore, in my opinion. Since I had an update on the cost, I thought it was reasonable. I guess it was in line with the time, given the period of time. That's why I have specified that one. Thank you. I had no expert engaged, no. Okay, thank you. Let's continue. The question about the movable and movable property. In 2008, you purchased a residential building in the village of Moskivtsi, Lubny district, Poltava region, worth 22,948 hryvnia. Already in 2015, you sold this house with approximately $880 USD, approximately this amount. Did you get funds from the sale of the house? I bought this house in 2008 to be closer to my parents. And not to live in their house. My parents lived in Lubny, and now my mother lives there. My father died in 2012. I, in 2008, bought this house when my mother was taking care of my father. She nursed him, and she nursed also her sister, who's my aunt. And in her apartment, it was too tight, because these were the chained to the bed sick people, you know, and I would come to them as to the hospital. Of course, I fulfilled my tasks. I communicated with them, but I didn't have the place to stay for the night. I couldn't spend more time there. So I chose to purchase a small house in the village. This village is 15 kilometers away from Lubny, not far from the river Sula, and I could fish there. In 2012, my father died, and then my aunt died, and I could come to see my mother more often and to actually stay with her in her apartment where she lives. And I didn't need this house anymore in Matskivtsi, since that was an old house as of 1926, made of clay. Half of it was in bricks, and every year it required some repairs, you know, some corner would fall down, well, things like that. Since I didn't need it anymore, and I didn't actually go to live to that house every month, actually. So I suggested the former owner, the daughter of the woman who used to be the owner of this house, and she died and she inherited the house. Her daughter sold me this house. So I asked this daughter to take care of the house, and she did. And then if I needed to repair it, I gave her money and she would do the repairs. But after leaving or owning this house wasn't relevant anymore, I offered this woman. I was thinking that she would take care of the house of her mother, and that it would be something like a home for her because that's where she grew up. And I didn't have any conditions for her, because in that village there are 50% of houses or buildings that just fall apart. Nobody is taking care of them. So I was thinking that this house will be preserved this way if the woman who grew up there would be taking care of it, and maybe somebody would even live there. So I asked her whether she finds it convenient for me to give her this house, and she asked me to re-register. I mean, to give the document to her son, a power of attorney to her son, and he could manage it. So I gave this power of attorney to her son, and without my notification, well, she was the only manager of administrator of this building. Her son decided to sell it in 2015. I know nothing about the sale or price, because I just transferred it to some caring hands. As much that was my thinking then. Okay, thank you, Anatoly Volodymyrovich. Anatoly Volodymyrovich, and one more question about you purchasing a 2018 Toyota Camry car. According to materials, you purchased it at a bit lower price as compared to the market value. In 2021, you purchased a 2018 Toyota Camry car, and cost of it was 313,000, according to the then NBU exchange rate of approximately $11,000. How can you explain this? So this was the auction, the USA. It was an open auction with bids and everything. So Way 8 company participated on behalf of me, so they would call me and say that the price go higher by $50, by $100. Are you ready? And I said yes, I'll take it, and the bid raised to $11,076, and it was sold. And this company took it to their parking lot, and I had 24 hours to transfer funds to bank details of this company. I did it. Then I had to transfer funds for transportation, something like $2,000 approximately, for transportation in the USA and then outside USA, and I did that too. And then 2 months later, the ship came to Odessa, and my task was to pay customs duty and also repairs at my cost, because there were some, defects. Where the lights are, the rear part of it, the cap of the trunk. It was all repaired, and then I came to the place of registration, and I also repaired it with my own funds. And then I came to the place of registration and got the state registration plate based on these documents. I have this full chain of all this data with my last name everywhere. Madam Hannah, please.
So I have some questions concerning the business of your mother. Your mother, sister, and nephews are the founders or managers of numerous limited liability companies and enterprises in
Пробачте,
the
якщо
city.
I beg your pardon. Please allow me. I can answer these questions, without the broadcast live, because these questions are not for me. I didn't get the permission to disseminate this information. My sister didn't give me her consent. Okay, let's limit our broadcast.
We also have several questions regarding errors in declaration. Namely, on August 2nd, 2016, you were appointed to the position of head of the department for particularly important assignments of the Prosecutor General's Office of Ukraine. And why do you not declare in your declaration for 2016 the salary received from the Prosecutor General's Office of Ukraine? Thank you for the question. This is when the electronic declarations were first introduced, and I believe that I was in a hurry, and maybe I was not attentive enough. And as my university teacher said, I did not go through with it. This is my mistake, and I do acknowledge this mistake. I was supposed to provide this information in the declaration, and I did not do this. I can say that this is a school student mistake, but it is a mistake. Thank you. According to the information provided, in 1995, you received a certificate for practicing law. Do you agree with this? Yes, I do. In 2012, you suspended the right to practice law, and then on January 25th in 2016, the right to practice law was renewed, and you stopped it again on August 5th, 2016. Do you consider yourself a member of the National Bar Association of Ukraine? I believe that I'm a member without any responsibilities, without the mandate. And what do we understand by the mandate? This means having the rights and freedoms. I do not have any rights. I do not have the rights to be elected or to be not elected, to pay the membership or not to pay the membership. So basically everything that is foreseen by the Article 5 of the statute. Allow me to clarify my question. You did not recuse your membership from the National Bar Association of Ukraine. You simply stopped your activity of practicing law. So basically this is your interpretation of the law. I believe that I explained this through the Article 37 of Constitution of Ukraine. Suspension of the activity is a temporal suspension of the activities. So I did not stop a legal power over a certain process. By suspending practicing the law, I introduced this temporary pause. According to the Article 37 of Constitution of Ukraine, the President of Ukraine can stop the eligibility and authority of the documents by questioning their authority, which makes this decision not a final decision, but which makes this article lose its power for a temporary period. Therefore, my membership was suspended. Okay. You're a lawyer. You had, in your working experience, you did have quite high positions in the General Prosecutor's Office. So you believe that you ceased to be a member of the National Bar Association of Ukraine just by saying this. According to the law of mitigating the risks of corruption of Ukraine, and according to the Article 46 of the law, in your declaration you must reflect information that the subject of the declaration is a member of the National Bar Association of Ukraine, even if the right to practice law is suspended. Now, the question is, in your opinion, personal beliefs can be the basis for non-compliance or compliance with the current norm of the law? Yes or no? No. Then why did you not declare this? If you allow me, I would like to quote, we know Constitution, please do not quote the Constitution. So you are aware of paragraph 189. Yes, these are the NAPC clarifications. So it says directly that in the declaration you need to reflect the information whether the subject of the declaration is the member of an AAU, even in the cases when the practice in law has been suspended. In this case, I believe that NAPC takes the position towards a certain public organization, namely the National Bar Association, amid other organizations. And in this case, so this is a norm of a so to say soft law. And this position is a violation of the balance towards other public organizations. For example, I myself am a member of my housing association. I am a member of the Association of Garage Owners, and I'm not supposed to reflect this in my declaration. I can be a member of any other association of writers, should I be a writer, or musicians association. And I believe that suspending my right to practice law is my temporary exclusion from a certain status. I believe that the only institution or organ that where you cannot suspend your membership is only the organ that Viktor Suvorov mentioned in his aquarium. So these are special law enforcement organs. For other associations, this is just a period of work. While you work, you are a member of this association, and you are supposed to follow the statute and the oath, and if you do not work, then these norms are not applicable to you. This is my position. Thank you for the clarification. Anatolii Volodymyrovich, in the single register of attorneys in Unified Register of Advocates of Ukraine, you indicated your working address, Mala Zhytomyrska 8. So this was the period when you worked as the advocate. Explain what right you own this premises on, and do you use this property? This was the property, so back then, in 2016, it was the property that was used by attorney firm, and I talked to the manager of the Advocate Association, and I asked him if he allowed me to organize and conduct meetings in this building, should I have such need? He talked about this to his colleagues, and the colleagues agreed to provide their office for as a meeting room. So he did tell me, okay, if you have a client, you can conduct your meetings, your work meetings here. Since I did not have any clients, I did not execute this right. I didn't pay any rent or any other financial contribution, and this is how it went. So basically, you received the right to use this property. And starting from January 2016 until August 2016, you were considered to be a practicing attorney who is supposed to indicate their working address, because he cannot work without the working address. Yes, that's why I specified this particular address. Why did you not specify this property in your declaration that you were eligible for using this property as your working address in your declaration for 2016? Because I did not use it. This was a hypothetical scenario in case if, so I didn't have any written agreement. What if I have these clients? So I do not have any arguments for putting this in declaration. Do we have any other questions from my colleagues? If there are no further questions, then Mr. Yezhov, we're very thankful for your answers, and we consider this interview complete. And Anatolii Volodymyrovich, you can make a short closing statement. Thank you for the opportunity. I would like to express gratitude to the members of AGE and to the supporters of your work for the immense work. I learned a lot about myself and about my relatives. I came here to show my desire to work with the justice and rule of law, as the Venetian Committee mentioned, with all the definitions of rule of law, and I came here to bring us closer as the public to fulfilling the efficiency of available legal tools. Thank you very much. It was a pleasure, and I wish you a great day. Thank you, Anatolii Volodymyrovich. Dear colleagues, at this point, the interview with the candidate for the judge of the Constitutional Court of Ukraine